Good morning and thank you very much for joining us. You're watching Biz Check live from Broadcasting House. This is our national headquarters. My name is O'Brien Kimani. The big news of the day, we are keeping an eye on what's happening at the Milimani Law Court, where the petitioners and the respondents in the case involving the impeachment motion against the former deputy or the impeached Deputy President Rigathi Gachagua is expected to take place in a minute from now. And now we want to take you to the High Court, where our court reporter Ruth Wambui is on standby to give us an update on what exactly is happening and the status of the hearings, if any. Ruth Wambui, if you can hear me, kindly take it up and give us the update.
Thank you so much. Thank you so much, O'Brien Kimani, back from the studio here at Milimani's High Court. We're still following up on the matter of the embattled Deputy President Rigathi Gachagua's case, whereby today, as scheduled by the bench yesterday, in this morning session, you are waiting for them to come in so that parties can discuss on what transpired during the National Assembly and also during the Senate. And I do not want to preempt on what the parties will discuss, but I have the petition from the petitioner side, the Law Society of Kenya, represented by Emeritus Nelson Harvey, and also have from the respondent side, I have Professor Tom Ojenda. So I just want Nelson Harvey to tell us what some of the issues that they are going to raise when the bench comes on board. Welcome, Nelson Harvey. Can you tell us what are some of the issues that you're going to raise?
Well, first and foremost, I appear for the Law Society of Kenya,
yes,
who is an interested party and not a petitioner. Yesterday, when we left court, the court had made two directions. One was that the two applications seeking to disqualify the bench will be heard today at 2:30. In the meantime, at 9 a.m. this morning, the bench is supposed to come and deal with the issue of consolidation of the various petitions that have been filed. Remember, there are two cohorts. The first cohort is the one that was filed before the decision by the National Assembly and the Senate to impeach Rigathi Gachagua. The second cohort of petitions are the ones that have been filed subsequent to the decisions of the National Assembly and the Senate, and the further decision of the National Assembly approving the appointment of Professor Gideon Kibure to replace Rigathi Gachagua as Deputy President. Now, this morning, the expectation is that the judges will give directions as far as putting together all these files is concerned, with the expectation that we'll have either one or two lead files that will be used to take proceedings.
And from the Law Society of Kenya, being an interested party in this matter, what that would do maybe to tell the bench?
Well, as the Law Society, our interest is the public interest. And throughout these proceedings, there are two fundamental issues that we want to address the court on. One is public participation. As we speak right now, the public participation bill is still lying torpid somewhere. It is imperative that we have a Public Participation Act that will guide the manner in which public participation is supposed to be taken. That's number one. Number two, there may be need for there to be the impeachment of the President and the Deputy President Act, because we do not have an elaboration over and above the mere pillars given in the Constitution on how this is supposed to be undertaken. And going forward, it would be good to have legislation so that whoever is undertaking this process can have a yardstick, and whoever is challenging the process can also have a yardstick to say these are the parameters in respect of which the inquiry for the removal of the President or the Deputy President ought to have been undertaken, and it was undertaken. As we speak right now, much of this process has gone on. Those two areas are one that appear a little bit blurred, and in respect of which legislation is required.
Thank you so much. We don't preempt everything here from the bench when the court comes in. O'Brien Kimani is still not yet finished. I have Professor Tom Ojenda, who will represent the side of the respondents, and they also have issues that they are going to raise when the bench comes to sit in. And just to bring on board Professor Tom Ojenda from the respondent side to say what are some of the issues that they are going to raise when the bench starts its sitting officially. Welcome, Professor.
Yeah, thank you.
Yeah.
The application is by the applicants. So we'll wait and respond. We will not resist. Yeah, we'll wait and listen to the grounds and respond. Yeah, we're ready. I think our interest is to discharge the interim orders, so that the first secretary can be sworn in as deputy president. I think what is clear is that the impeachment is final. That is my understanding, it's final. And Article 155 says that it is final. And there's no turning back. The first secretary should be sworn as quick as yesterday, because this country cannot go on without the president. We must have the that is a concern.
Just before I let you go, Professor, yesterday we heard from the bench when the petitioners said that they are not satisfied with the bench as it is because it sat on a Saturday. And then the bench said that the applicants or the petitioners are raising issues when things do not go their way. And it said also when they got the conservatory orders, it's like they got settled. From your side, who you want, I know from your side you want the orders set aside. So what's your move? Because maybe from their direction they want this matter to delay. What do you have to say about that, and what will be your response from your side?
It is the delay that we avoid, and that is why we want the application for setting aside to be heard, because any delay affects the public interest. The public interest is that a position as important as that of the leader should be filled, and parties cannot have interim orders, temporary orders, and avoid the substantive decision hearing the application set aside. That is why we will ask the President to prioritize that application, so that after hearing this refusal goes straight to the application process. The other matters can be determined.
O'Brien, we have clearly listened. That's some of the issues that are going to be raised up when the bench starts sitting officially today. From the respondent side, you hear they want the application for setting the conservatory orders aside be given priority. Whereas, yes, from the petitioner side, you heard yesterday what they want. Back to you, O'Brien. We'll update you more as they happen.